Jamal Jones, the founder and principal attorney at Jones Health Law, and today we'll discuss emergency suspension orders and what you should do if AHCA shuts you down. An emergency suspension order, or ESO, is one of the most serious enforcement actions taken by the Florida Agency for Healthcare Administration, otherwise known as AHCA. When an ESO is issued, it immediately suspends a licensee's ability to operate without prior notice or a hearing due to concerns about immediate threats to the health, safety, or welfare of residents. For operators of adult family care homes, or AFCHs, it is crucial to understand what an ESO is, why it may be issued, and how to respond effectively. So, what is an emergency suspension order? An emergency suspension order is an administrative action authorized by Chapters 408 and 429 of the Florida statutes. It empowers AHCA to halt operations of a licensed healthcare facility or provider, including AFCHs, if the agency finds that continued operation poses an immediate danger to the public. The order takes effect upon issuance and is intended to prevent harm while AHCA conducts a deeper investigation or awaits the outcome of other administrative or judicial processes. ESOs are legally binding and non-compliance can lead to further legal consequences. So when are ESOs issued? AHCA may issue an ESO based on findings from inspections, complaints, or referrals from other agencies. Some common conditions that can trigger an ESO include the following: serious health and safety violations such as unsanitary conditions, inoperable utilities, or fire hazards, abandonment of residents or failure to provide 24-hour supervision as required by law, failure to report a resident death or injury requiring medical attention, lack of access to food, medication, or essential services, background screening failures or evidence of abuse or neglect. ESOs are not reserved only for egregious misconduct. They may also be used when cumulative deficiencies suggest systemic failure to comply with licensure requirements. Legal authority and process. When AHCA determines that an ESO is warranted, it issues a formal order that cites the specific legal grounds and facts leading to the action. This order is typically delivered by certified mail or hand-delivered by agency staff. So what happens to a licensee after an ESO is issued? Once an ESO is issued, the provider must immediately cease operations. This may involve arranging safe relocation of residents, notifying family members, case managers, and healthcare providers, standard care continuity expectations, of course, cooperating with AHCA to ensure an orderly transition. Failure to comply can result in further sanctions, including revocation of licensure or civil penalties. So how does one respond to an ESO? Well, receiving an ESO can be distressing, of course, but there are procedural steps a provider can take. Firstly, review the ESO carefully, understand the findings and violations cited. Then, we would recommend consulting with an attorney. An administrative or health law attorney can advise on rights, defense strategy, and possible resolution. Make sure to gather evidence and documentation. This includes policies, logs, photographs, or other records to support compliance efforts. You may consider requesting a formal hearing and preparing a corrective action plan. Under Florida's Administrative Procedure Act, providers are entitled to challenge an ESO through a formal administrative hearing. Showing a willingness to correct deficiencies may assist in future negotiations with AHCA, commonly used in AHCA and DOA proceedings. So how do we prevent an ESO? Well, prevention starts with a strong compliance practice. Some proactive measures you can take are maintaining proper documentation, such as health assessments, medication records, incident reports. Conduct routine internal audits and mock inspections. Ensure all staff and household members meet background screening and training requirements. Respond promptly to any resident complaints or grievances. stay informed of the rule changes, and in conclusion, emergency suspension orders serve a critical protective function in Florida's healthcare regulatory framework, but they can also significantly impact a provider's reputation and operations. Understanding what ESOs are, why they are issued, and how to respond effectively can help providers navigate these challenges and ideally prevent them through robust compliance and documentation practices.